to grease the skids, if you will, for the Republican nominee. That's what we're seeing from Judge Eileen Cannon. We talk about her a lot, but she's not the only one. This is an all or nothing for them. The very notion that a 501c3, I know we're going to talk about that later, but that this is all or nothing. They literally, you got to understand, these are people who are prepared to, grown people, get up in the morning and all dress the same. Is that the most bizarre thing you've ever seen? The members of Congress coordinated their outfits for a week during a unprecedented trial to sit in a courtroom and mean mug a jury. That's what happened. That's not what I think. That's what we watched. They wore blue suits and red ties.
Yes.
And don't miss, Dianne, that while they're there, and don't miss, Dianne, while they're there, there's still committee hearings going on Capitol Hill that they're missing.
Right.
Oh, yeah, of course, because right now, my point is, this is the most important thing for them. The Speaker of the House is literally polling and counting numbers to see how many votes they can get to protect a state, a defendant, a criminal defendant, from punishment, just punishment, on a state trial system. That's what they're doing. And I think that that's why I always love the Transformative Justice Coalition, because we stay in this space and don't underestimate anything that they do. But how do we wake folks up? These people coordinated their outfits and dressed alike. They can't coordinate anything in their jobs.
And Dianne, they flew,
got on a plane and flew, and neglected, as Daryl just pointed out, neglected their duties as House members, because this is what they see as their duty, protecting their folks. They're on a clock, folks. They're on a clock.
Lord.
They are on a clock, and everybody is reading the script. It doesn't matter how absurd. What we know is that all of the protests on the steps won't matter because they continue to flout it. They have pretty much told Congress to go kick rocks.
My Lord. And for all the panel, why is the House, remember I said House members. I didn't say senators. Why is the House of Representatives more active on this subject of Supreme Court, ethics and Supreme Court, appropriate behavior than the Senate, which actually confirms judges to the federal court, including the Supreme Court? Why are they more active in the House instead of the Senate? Why is the Senate so passive, everybody?
I don't think that's permanent. See, only because I think that Senator Schumer is offended. I literally think that they are offended and regrouping, and I do expect something from the United States Senate. They wrote the letter, and the chief, was it Judge Alito, wrote them back and saying, no, not going to meet with you. Chief Justice, I gotta believe that they are in the war room right now trying to figure out the what's next, and whatever that what's next is going to be big. I don't think they're going to take this sitting down.
Terry, same question.
I absolutely hope Dianne is right about that. I like to think that would be true. I have been repeatedly disappointed by Senator Dick Durbin of Illinois. He's the chair of the Judiciary Committee. I don't think he has been nearly aggressive enough in responding to what is obvious corruption, deep money-grubbing corruption on the Supreme Court. That $4.7 million for Justice Thomas, where are the hearings? Why are we not scheduling hearings on that alone? And now this scandal after scandal after scandal involving Samuel Alito, Where are the hearings about that? Durbin has not scheduled hearings. He is not taking an aggressive posture on that. I have a lot of opinions as to why that might be. I get very frustrated with elected officials that I consider to be corporate Dems, the corporate Democrats. They just seem sometimes to be afraid of their own shadow. I think what they're actually afraid of is their funders, and their funders are, corporations and very rich people, and they can only go so far in alienating them. Right. So I think that's a huge problem. I have faulted Chuck Schumer in the past for that, and Dick Durbin repeatedly. So but I hope Dianne is right. I hope that sort of somehow the weight of these scandals will eventually become so great that Schumer and Durbin have to take action.
Yeah.
And, Terry, one of the interesting questions I think that's out there that people are not necessarily grappling with is this. We know that right now that the favorability, right, the integrity of the Supreme Court of the United States is at a historic low right now as we speak, and it looks like it's continuing to drop. In one of our prior shows, one of the judges in the federal system said that the one thing that the Supreme Court has, the only thing that the court system has for people to abide by its decisions, are their faith in the institution. They don't have, anyone, a police they can send in or anything like that. The judges are relying upon people of the country to believe in the righteousness of what they do. Given the ethical, elements and the ethical questions that have been raised by Justice Thomas and Justice Alito, how do we square that with what the court needs to do to get back on track so that people begin to have more faith in it?
Yeah, well, what they would need to do is to start, first of all, making rulings according to the law, not according to extremist right-wing websites. I go back to Justice Alito's opinion in the Dobbs case. He basically cut and pasted it off an extremist website. There's no real grappling with the very serious constitutional issues underlying Roe v. Wade and all the cases that came after Roe v. Wade, and then the Dobbs decision. There's no real intellectual. He made no intellectual effort to grapple with any of those questions. He just wanted a result. He knew the results he wanted. He saw some extremist writing that he apparently likes, and he cut and pasted it and made that his opinion. And then, for most of what I've read, it is very probably Alito who leaked the Dobbs decision in an effort to keep Kavanaugh in line and to make sure that Justice Kavanaugh did not break and go with Justice Roberts, who wanted to impose a 15-week abortion ban nationwide rather than overrule Roe versus Wade outright. So all of these political machinations on the court, they got to stop that. They have to start making rulings based on the law, right? But, it's not just Alito and it's not just Thomas. It's Justice John Roberts himself, who, in my personal opinion, has never seen a black person he thought should be voting, right?
But apparently we know he knows some Muslims, though, right?
Right, at least we know that.
Right. But he didn't say he wanted them voting.
You're right about that.
Right.
And Barbara, it doesn't stop at the Supreme Court, though, right, Barbara? Because what we've seen are a lot of appointments from the last administration that have really taken aim at the Constitution, and that's where we fall into this Fearless Fund, right? The Fearless Fund coming out of Georgia. It's the same issue that's coming from the court that is overturning a Civil Rights Act that's been in place since the ending of the Civil War, right? They're giving this new interpretation to it. Barbara, help us on that.
Yes, everybody, let's just sit back, close your eyes for a minute, and think. Black women, a number of years ago, sit back and say, there's something really wrong in this country, that only 1%, less than 1% of black women are venture capitalists, have their own businesses, are able to compete. We women, we're not asking for governmental money. We're going to go into our own pockets and ask our sisters, brothers, friends, allies around the country to raise money so that we can give $20,000 per year to Black women to have the ability to at least try to compete in this marketplace. Open your eyes to what happens afterwards. Edward Bloom and his American Alliance for Equal Rights files this lawsuit against this fund that the women created called the Fearless Fund. And he sues all elements of the fund, the foundation, the management, everything about the fund he sues, and says that this not-for-profit, which is dedicated to giving money, grants, is actually the discriminatory entity on the basis of race and ethnicity. And this is the same Edward Bloom. Come on, everybody. Don't get confused about who he is. He's the same attorney who was the lead counsel in the Students for Fair Admissions case, the SFFA case that got the Supreme Court to ban affirmative action in higher education admissions. So now he is out there trying to take that case and extend it to grant programs, this little tiny grant program. I mean, there are foundations, folks, with billions of dollars. This poor little fund, had given out, I think, about $2 million in total, and you got foundations sitting around with billions of dollars. But this is what he targets. This is what he wants to go after, is he wants to shut down this foundation, this fund, from giving Black women that opportunity by saying, why not? Why can't anybody sue? But what he does is he got away with it in SFFA, and that is bringing these people before the court and saying they've been injured who never even applied. These women that he, quote, represents, if they're even women, we don't know, but these people, and if you read their affidavits, they never alleged that they even applied for a grant. They are just what you call nothing but straw men in this battle, and they're just being used to take down any programs to try to advance African Americans in a society that suppresses us so bad. And I just want to say to everyone, next week we're going to go deeper into this case by some of the litigants. We're going to talk about this case more. But I want everybody to understand why this is so troubling. It's private money, not state money. It's not governmental money. It's private money. It's money to help those who have clearly been disadvantaged in our society to have some kind of opportunity to fight to be equal. I thought, and the case is being brought by a front organization and by people who can't even show they were injured. I go into this injury question so strongly because if you look at the Court of Appeals decision itself, it's a total of 26 pages covering all the issues in this case. Remember that at the lower court level, the district court denied the motion for an injunction. And the district court said that there was no clear evidence that the American Alliance for Equal Rights, AAER, would prevail in the decision because of the many arguments that were brought up in favor of the program. And so the appeal to the 11th Circuit was over this issue of wanting a preliminary injunction. What the 11th Circuit has done is issued a preliminary injunction, which has stopped any dimes flowing from this fund to anybody. And they have a whole lot of base